Employment Roundtable podcast is produced by the Gable Gottwalls Law Firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebright, and today we're talking with the EEOC's Holly Cole and my Gable Gottwalls partner, Paula Williams, about the second of a two-part series titled COVID-19 and Disabilities. This episode looks at the intersection between the ADA and COVID long haulers. So Paula, I have to admit that you first used the term long haulers and I had no idea what you were talking about in relation to COVID. So will you please explain what a COVID long hauler is?
Well, I'm not a doctor, and I think that
but you play one on TV.
Right. I play one on TV. I play one on this podcast. Well, so a COVID long hauler, I think that definition has evolved and it's really evolving as we see more and more people develop strange symptoms and ongoing symptoms. You know, I know someone through Facebook, right? So, but someone I saw on my Facebook newsfeed the other day that someone I know months after COVID had completely resolved, no other symptoms, has now developed the condition with your senses where smells are strange. So good smells smell bad, bad smells smell neutral or the like, and it can really impact your daily life. And so that's an example of what I'll call long COVID. The EEOC addresses long COVID in the guidance that I'll just mention because we mentioned it in part one of these episodes, but the EEOC has released lengthy guidance that addresses all kinds of issues that are very helpful for employees and employers to know how to handle certain situations. And the EEOC has discussed long COVID, gives a link to the CDC website, but it's someone who's experiencing COVID-19 related intestinal pain, vomiting, nausea, symptoms that are lingering for months, even if it's intermittently. And it substantially limits a major life function, which is why we're talking about disabilities here. And so that's long COVID. And that is one situation, and we'll talk about a few others today, where the EEOC has said COVID-19 may be a disability in certain situations. One of those is long COVID.
Thank you. That's super helpful. So then Holly, are there differences in how to evaluate the application of the ADA to people who experience the standard duration of COVID symptoms and long haul? And then also, I think Paula hinted at some other situations in which COVID might result in a disability. How does the EEOC sort of evaluate those issues?
Yeah, thank you. That kind of echoes the point Paula made about, we start with the idea that, typical COVID, the kind that, might last for a little bit and then it resolves, that's not a disability as the Americans with Disabilities Act defines a disability. It's a short duration. It's not, it doesn't affect, major life activity. It doesn't meet that criteria. So we start with the idea that many people, maybe hopefully most people, don't become a person with a disability just because they test positive for COVID. So then the other part of that are the people who do, either develop a disability because they have become because they've tested positive for COVID, or they already had a pre-existing condition. They had a disability already, and then getting COVID made that disability worse. So, like Paula mentioned, there are things like sometimes people develop multiple day headaches, migraines, dizziness, brain fog, a lot of gastrointestinal issues that we've seen. Sometimes heart disease can be exacerbated by COVID. So those situations, those would kind of fit that long hauler definition or long COVID definition that we're talking about. But it's that group of people that employers really have to deal with when we're talking about reasonable accommodation issues, because those are the folks who, one, are going to need an accommodation, and two, entitled to an accommodation in the workplace if that can be done. So that's, employers, I would think, ought to focus on those folks who COVID has really either exacerbated an existing disability or it has become a disability because their conditions is so severe and has not cleared up in a short-term time.
And so, I think that leads into the next question then, Paula, which is, how does an employer know whether an employee's COVID experience results in a disability, and whether that be because it's long COVID or because it exacerbates another condition?
Yeah. So in this situation, employers are going to follow the same interactive process that they're used to know if any employee has a disability. Now, the interactive process comes into play when the disability is not obvious. So, if someone is missing a limb, then their disability is obvious. But with long COVID and, hey, I'm having heart palpitations, it's not obvious. And so the employer gets to ask for a doctor's input, the employee's doctor's input on what their disability is, how it prevents them from performing their essential job functions, and what accommodations would allow the employee to perform their essential job functions. The employee doesn't get to pick the accommodation. They can certainly ask for a specific accommodation for the employer to consider, and the employer should consider that. And the employer should also consider if there are other accommodations available that can accomplish the same purpose. Now, if I can I talk for a minute about temporary work, Talitha?
I would love that. Yes.
Okay. So, one of the things that we've seen a lot of is employers who sent workforces to work temporarily from home. And then in times that COVID comes back down, they bring everyone back in. And then we have employees who ask for remote work as an accommodation. And the employers in those situations need to be prepared to explain why the move to remote was permissible when COVID was high and it was taken as a health and safety mitigation effort, or to keep people healthy, keep the business running, and why it's not available as an accommodation now. So sometimes when we kick everyone temporarily remote, they aren't actually able to perform all of their essential job functions. And we allow that for a temporary time in order to accomplish a specific purpose, which is to keep everyone safe and healthy and keep the business running, keep the economy going. When everyone's pulled back, the employer still needs to consider and evaluate that request. And the employer needs to also evaluate, okay, if I'm not going to allow temporary work, is there another accommodation that accomplishes the same thing? So if I have an employee that's now on oxygen because of COVID, and now they're going to be on oxygen going forward, and they're at a heightened risk for if they contract COVID again, for having a negative outcome, and they request remote work to accommodate a disability. Can we move their office away from others? Can we have them go in an entrance that's different from other employees? And taking a look at their essential job functions. Can they perform their essential job functions remotely? If not, which ones could they not perform? And so it's still the same process. Employers also want to be cautious of how they treat people who have had COVID, and specifically long COVID or conditions that last several months. There's no magic timeline for when it becomes a disability, but the EEOC has used the word several months and has also referenced a few weeks for when it may not be a disability. It's always fact specific. But once an employee, I'm talking a lot, so thank you, but once an employee has that disability, it may resolve. They may not have the disability for life, but you can also have a disability discrimination claim when someone has a record of a disability. So they had a disability at one time and they don't anymore, but you're treating them a certain way, or you're not promoting them, or you demote them, or the like. You treat them differently because of a record of that disability they had. And employers can also draw a regarded as claim. And, Holly's the expert on all this stuff, but a regarded as claim where maybe they don't have long COVID, but you treat them like they do. And so you are still using a disability to make a negative decision in the workplace, even if they don't actually have that condition. They may still have a disability claim.
That is awesome. I mean, again, I've learned so much from hearing the two of you today. Particularly, I didn't know anything before about having the disability in the record and how that could be the basis for a discrimination claim. Am I on mute? No, I'm not.
Nope.
Okay. Sorry about that. Good.
I wanted to, if we have another minute, I wanted to kind of circle back to something that Paula said, just to highlight the importance of the interactive process. That is such a fluid, fact specific process that employers and employees engage in. And that dialogue needs to be open and often. Mm-hmm. You're talking about telework, and many of us are still teleworking. We're here mid-February of 2022, and we're, and I'm still teleworking. And so what is important to keep in mind, and I think we're all becoming more aware of it, is our economy, our workforce, how we do business has evolved out of necessity because of the pandemic. And I'm shocked at how much I can actually get accomplished at my house when my cat's not sitting on my lap, but she just got down. So, so I think it's important for employers not to just take a hard and fast rule that says, oh, no, you have to come back in the workplace. Because they have to step back and go, okay, well, it might be feasible to do this. You've been doing it for 2 years, so it might be okay. So I like that idea of just keeping that dialogue open. And you got to, businesses have to stay in business, and they got to be concerned about the productivity, their finances, all of that kind of stuff too. And then balancing that with, can we get this work accomplished if we're giving this accommodation too? So it's a lot to consider.
It is, but I think the discussion has really highlighted what we've all kind of experienced in the last 2 years, which is that we're probably a lot more flexible than we ever realized we could be, and a lot more able to adjust on the fly to evolving situations. And so just if employers can sort of keep that mentality as they approach these issues with their employees, then it'll be a good thing for everyone. So thank you both for that input and that advice. So once again, thanks very much, Paula and Holly. And thank you to our listeners for tuning into the Employment Roundtable. Please join us next time as we provide an overview about religious discrimination in the workplace. Thank you.
All right. Thank you.
The Employment Roundtable podcast is produced by the Gable Gottwalds Law Firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.